They demand it.
Yeah.
Oh, my God.
And then I'll just.
So keep me on, so I don't rise to the
Would the Senate please come to order? We will take a moment of silence in lieu of a devotional. Thank you. Are there any announcements? Senator from Rutland.
Thank you, Mr. President. Actually, I have two announcements. So first, just an update on political pins on behalf of the Friends of the Vermont State House. Just an update. First, the order has been processed. The die is being manufactured now, and delivery is expected no later than the veto session. So, if there's no veto session, Friends of the State House are working on an alternative method for distribution. Just wanted you guys to know that that's the status, and we're working on improving the delivery date. Second, Vermont Eagle Scouts tomorrow. The 2024 class of Vermont Eagle Scouts and their parents, who are constituents, will be in the State House at 9:30 in the morning. Resolution reading is in the House chamber. I want to thank everyone for supporting the resolution. This year we had all 30 senators and all 150 representatives who co-sponsored the resolution, so I thank you for that. At 11 a.m. tomorrow is a formal welcoming in the Cedar Creek Room. Curator David Sheets, thank you, Sheets, will be our guest speaker. We chose Dave to celebrate his career efforts on maintaining the grandeur of the State House. We thought that was an appropriate and befitting opportunity. And then tomorrow at 11:30, I know it coincides with the start time of the Senate, but they will be doing a group photo in front of the State House because it's good weather. I know that politicians love group photos, so this is an opportunity anyway. And then 12:30 tomorrow is lunch at the Capitol Plaza, and 2:30 is the State House tour. I did yesterday hand out a reminder of the Eagle Scout celebration, but more importantly on the backside again is the list of the 51 Eagle Scouts with the hometowns. So for you that want to, again, get some points with your constituents, hometowns are key here. And I'd just like you to welcome your constituent scouts and their parents tomorrow in the State House. Thank you, Mr. President.
Thank you. Are there any further announcements? Senator from Chittenden.
Thank you, Mr. President. We have a very special birthday being celebrated in the Senate today. While it is not the actual day of her birth, which is over the weekend, it is a milestone that deserves more than one day of celebration. I hope my affection is obviated by reciting a birthday poem on the Senate floor, because this is the only time you will hear me do this, ever. But we all know it's her love language, and we love her. So here is a birthday anagram, crowdsourced from many members of the chamber, for the senior senator from Windsor. A is for admirable, abundant with grace, an animated smile lighting up every place. Absolutely fabulous, bold through and through. Applaud this Anglophile, which is not an insult in any way. So artsy, so true. L is for loyal, lavish, lovable, bright, living out loud from morning to night. A late night lounge lizard, loquacious, lively, in laughter and warmth, she shines so divinely. I is for inspiring, inclusive, so wise, an irreplaceable gem with intelligent eyes, an instigator, inventive, with insight so deep, an intriguing individual, dreams hers to keep. S is for sincere, smart, and sensational too, studious yet playful, too serious? Not you. Superb and salubrious, shamelessly herself, with spirit and sparkle, a queen of true wealth. O is one of a kind, original, bright, optimistic, open-minded, a true guiding light. Outgoing, out loud, only one, so divine, the one and only Allison, forever she'll shine. N is for natty, which somewhat I thought means smart and fashionable. Did I have to look that up? Notable, nourishing of heart. Never tired, never defeated, always doing more than her part. Nimble, noble, and knowledgeable too, silent K. Nevertheless, she persisted, the bravest of few. So here's to Allison, who truly does it all, abundant with joy, standing proud, standing tall. May your year be as fabulous as your radiant way. Happy birthday to you, and cheers to your day.
Happy birthday, Senator.
Senior Senator.
Are there any further announcements? Senator from Chittenden.
Senator Clarkson, she stands with resolve in halls where tough issues evolve. With roots overseas, she serves with such ease, a voice that helps problems dissolve.
Are there any further announcements? Senator from Chittenden.
I would be remiss if I didn't bring a limerick myself. Senator Clarkson, a force with some sass. In the Senate, she'll make a great pass. With a wink and a jest, she'll outshine the rest, then leave with a laugh and a glass.
Are there any further announcements? Seeing none. We have H 219, an act relating to establishing the Department of Corrections Family Support Program. And it is referred to the Committee on Appropriations per Rule 31 referral. We have H 481, an act relating to stormwater management. It is referred to the Committee on Finance per Rule 31 referral. And we have this monster. H 493, which is committed to the Committee on Finance per Rule 31 referral. Orders of the day. S18, an act relating to licensure of freestanding birthing centers, was passed by the House with a proposal of amendment. The question is, shall the Senate concur in the House proposal of amendment? Senator from Chittenden Central, Senator Gulick.
Thank you, Mr. President. So we have a proposal of amendment that came back from the House to the Health and Welfare Committee, and you can find it in the calendar on page 921. I'll go through quickly some of the changes. The first item is in section 1, subsection 2. Here, we just wanted to the House wanted to clarify that practitioners who work in birth centers mean that the meaning is an advanced practice registered nurse. So this was about clarifying the definition, who has a specialized training in childbirth, newborn care, and reproductive health care services. And you will see that in a couple of other locations. Also in section 1, under subsection 2352, license and prohibitions, this is clarifying who can own and operate a birthing center or a birth center. So it reads, a birth center may be independently owned and operated by a licensed maternity care provider or any other person who complies with the requirements of this chapter. And a birth center shall not offer or provide epidural anesthesia or cesarean delivery. That part just clarifies what birth centers can't do. So that was an important clarification. And then further on, you will find this is under 2359, so we're talking about rules here, and this is guidelines for hospital transfer. So when someone needs to be transferred from a birth center to a hospital, this just helps clarify exactly what's required for the Department of Health. For example, a requirement for written practice guidelines and policies that includes procedures for transferring a patient to a hospital if circumstances warrant, and you can see a whole list there, and requirements for written policies and procedures for collaboration with hospitals, laboratory and diagnostic services, childbirth education and parenting education support services, etc. I won't read the whole list. And then in section 2, this is in 8 VSA 4099D. We're talking about midwifery coverage. The House took out the word home births because Again, this is a technical correction. A home birth is not a birth center birth. So clarifying. And lastly, we're getting to the end. Section 3, we clarified the CON certificate of need exemption based on Green Mountain Care Board practice. So we took out a bunch of language here, and we put in excluded from the subchapter are birth centers that are licensed pursuant to Chapter 53 of this title and are proposed to be established and licensed pursuant to Chapter 53 of this title. So this is around certificate of need exemption. And lastly, section 4, you will see that we took out some language because we would like this to be effective on passage. The Health and Welfare Committee concurred with the amendments made to S18 as it came from the House, and we would ask that the body concur with the amendment. Thank you, Mr. President.
The question is, shall the Senate concur in the House proposal of amendment? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and the Senate has concurred in the House proposal of amendment on S18. Okay, we have third reading of H17. Are there any amendments prior to third reading? Please listen to the third reading.
H17, an act relating to approval of the adoption of the Charter of the Town of Morristown.
The question is, shall the bill pass in concurrence? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and we have passed H17. We have on the calendar for action H218, introduced on February 13th, 2025. It was referred to the Committee on Health and Welfare, which reports it has considered the bill and recommends that it ought to pass in concurrence, affecting the expenditures of the state. The bill was referred to the Committee on Appropriations, which recommends that the bill ought to pass in concurrence. Listen to the second reading of the bill.
H218, an act relating to fiscal year 2026 appropriations from the Opioid Abatement Special Fund.
Recognize the Senator from Chittenden Southeast, Senator Lyons, for the report of the Committee on Health and Welfare.
Thank you, Mr. President. This bill is really, it does include some policy recommendations for the opioid abatement advisory committee and process, but it's really mostly about the appropriation of money from the opioid abatement fund. And as you know, the opioid abatement fund is money that comes to us from a settlement with pharmaceutical industry regarding opioid addiction. The state will continue to receive funds, and I'll mention that in my report from appropriations. I will not go through line by line or appropriation by appropriation, but rather try to summarize some of the work that is here and the funding that is included in the bill for different projects across the state. And then one thing I think that's important to acknowledge is that in the past, some of these appropriations have been included in the budget, and now I think the advisory committee, the Commissioner of Health, and those of us on relevant committees believe that having this, all of this money appropriated in one place in a bill makes a lot of sense, because it does come from a special fund that is dedicated to these prevention, intervention, treatment for opioid addiction. So as you go through the bill, you'll notice that there are different sets of appropriations for example, for the preferred provider network, the substance use disorder folks, and then that's the first one on the first page of the bill. And then different monies being distributed to, for example, the Criminal Justice Reform Outreach Program, Department of Health for recovery residences, And some of these appropriations that are in the bill will be ongoing appropriations until the fund runs out. So the decision by the advisory committee is that these are important enough to continue over time, and I can share those with you, which ones in here are continuous over time. Should you like me to do that, I do have that list. Moving on to the second page of the bill, you'll notice that there are appropriations, as I said, that are continuing for, this one is for the city of Burlington, which is a continuation of appropriation that was made last year for the Opioid Protection Center, the OPC, and this puts additional funds into that. And the funding for that pilot program by statute will go on for a period of until 2028. There is money for Department of Corrections, in particular for behavioral intervention programs known as contingency management. So the money that is there can be used for positive behavior intervention, to keep people from relapsing to their addiction. There's also money that goes to the Champlain Housing Trust for wound treatment. As you know, when people are exposed to xylazine, they can end up with some really nasty wounds, and so there's money to help with that training. Then there are harm reduction programs that are being supported. And if you continue on to page, I'm going to try and go as quickly as I can, because I don't want to read all of the things that are here. But if you go to page 4, for example, there are a number of appropriations that will help youth in the state, and this is important for prevention. It goes both to prevention, but also treatment for youth. And so there are a set of 4 or 5 different appropriations on page 4 for that. There's also appropriations to the Department of Aging Independent Living for employment purposes, to help people gain employment in different parts of the state. There's money supported to the Northeast Kingdom for peer support specialists. This is a fairly comprehensive set of appropriations throughout the bill, which is pretty exciting for us to have the money to do this. Then an appropriation to the Criminal Justice Reform and Johnson Health Center. This is the health center that is associated with Jenna's Promise, so this is helpful to them when folks who are being treated at Jenna's Promise might need some medical attention. Then there's the Washington County Mental Health Embedded Recovery Coach, and then support for our folks under domestic and sexual violence providers in the Northeast Kingdom. One of the things that, if you look at page 5 of the bill, a small b at the bottom, I think this is critically important, that as this money is being appropriated, now the folks who are receiving the money are being asked to keep track of outcomes and do outcome measurements, so that any further appropriations can be based on data, so data-informed work that we all very much appreciate. Page 6 of the bill looks at some technical changes. So instead of talking about medically, MAT, M-A-T, medication-assisted treatment, we're now using the appropriate language, which is medication for opioid use disorder, or MOOD. I think we all continue to say MAT, so sometimes we'll be confused. And so that language is updated in following sections of the bill over page 7 or 8, page 8. Then you'll notice on the bottom of page 8 the use of the data. So the recommendations that the advisory committee makes will be based on and informed by the outcomes that they receive back from folks who have used the funds in the past will at least be data-informed decisions by the advisory committee. Then the advisory committee on page 9, some recommendations address how recommendations meet the criteria that are in specific sections of our underlying statutes. And so that would include meeting prevention, intervention, treatment, recovery, harm reduction work that is critical. So making decisions that those appropriations will be supporting work that will lead to prevention or intervention and so on. There is a recommendation on the advisory committee, which is also on page 9. One of the advisory committee consists of 16 members. The one member is a non-voting member, so that gives you the uneven vote. But the one member who is a non-voting member is the Commissioner of Health. The advisory committee made a decision that they would like to have a vice chair from a non-governmental, they're non-governmental members, and that vice chair is a voting member. So that's a change then to the committee. And then beyond that, some technical changes to MOOD, M-O-U-D, and the effective date is July 1st, 2025. So overall, there's some modest changes to the advisory committee, important changes to understand the outcomes for the money that's being appropriated and the work that's going on, and then to be used that in future decisions by the advisory committee. We heard in our committee from our joint, our principal fiscal analyst, our ledge counsel, a member from the city of Burlington, the sponsor of the bill, Teresa Wood, from our Representative Wood, Mark Levine, the Commissioner of Health, and we asked that the Senate support the bill as it came to us and as it comes to you from the Committee on Health and Welfare.
I would like to recognize the senator from South Chittenden Southeast again, Senator Lyons, for the report of the Committee on Appropriations.
So thank you, Mr. President. The Committee on Appropriations reviewed the funding available in the opioid abatement special fund. The special fund started out in 2024, 23 and 24 with over $26 million. $14 million has been appropriated last year, and there was an unappropriated balance of $12 million. From that, approximately $9 million is being appropriated in this bill before you as 218. So there are sufficient funds to support the work that's being done. Then we also looked at the allocations that will be coming to us from the settlement, and understand that the fund will gradually decrease over time, and we did look at that. But currently, the fund supports the work that's being proposed in S218, and we voted 7-0-0 to support the bill. Thank you, Mr. President.
The question is, shall the bill be read a third time? Are you ready for the question? Senator from Addison.
Thank you, Mr. President. I am the Senate's representative on the opioid settlement committee. Kind of surprisingly, neither committee that took up this bill invited me to come speak with them about the work of the advisory committee. But I just wanted to let the Senate know about the process that the advisory committee uses, and how we came to these decisions, which were unanimously supported by the advisory committee, which is chaired by the now former commissioner, who's no longer the chair, but the Commissioner of Health. And I've been on this committee since its inception. And this past year, we made a big effort to make sure we had a process that was open, and that we accepted and we did basically a call for applications from people around the state And we got, I believe, over 45 applications, if I remember correctly. And the committee, all the members of the committee read all 45 of them. It was a lot of work. And we we scored them and ranked them. And then the ones that ranked above a certain amount, I can't remember the scoring I think it was above 7 points, I believe. We had a whole conversation about that. We asked them to come in and do a presentation to the committee about their work. And that included why they were asking for the money, the budget, what they were going to do with it, and what their outcome measurements would be for that work. We made a big effort to provide funding to opportunities, programs, and opioid abatement services across the state. So you'll see on the list in the bill, there's the Northeast Kingdom, Franklin County, Brattleboro, Windsor, Rutland. We tried to hit all of the counties. I think actually somewhat ironically, the only county that's not directly gets a grant is Addison County. So you'll see I was totally fair in trying to rank them and making sure that we were using best practices, also that we were following the guidelines, not only of the settlement funds, but also the measurements that the committee itself had created. The committee, as the chair of Health and Welfare mentioned, is a 16-member committee. It includes a House member and a Senate member. It includes people with lived experience with opioid use and recovery. It includes members that are appointed by the Vermont League of Cities and Towns. So it is a very inclusive. A member of the judiciary is also on it. And so we tried to make sure that we were covering all of the bases. It was a unanimous decision, and I think the process was really excellent this year. And soon we'll be starting next year's process. So if any of you know in your districts of things that might need to be covered and you want to talk to me about a proposal, please do, and I can talk to you about the work of the committee. So thank you, Mr. President.
Question is, shall the bill, Senator from Chittenden?
I just would like to say, Mr. President, I tried to make the report short, and there's a comment to be made. And I do thank the senator from Addison for clarifying the committee process. It is important because in previous years, there's been some disagreement between what the committee can do and the recommendations that the Department of Health might make to the legislature about this. Because the initial guidance document that has come to us from the settlement indicated that it could be simply an executive branch decision. But to our credit, in this chamber, we made a decision to have an advisory committee so that we could understand what the needs are around the state and to have a more collaborative process. So, but it is critically important. I think that we all do understand that it is a process and that the advisory committee's report has been adhered to, and that is that's a new process, and it's great. Thank you.
Are you ready for the question? Senator from Rutland.
Thank you, Mr. President. If I could interrogate the reporter from the Health and Welfare Committee.
The reporter is interrogated.
Thank you, Mr. President. So first I want to thank the senator from Chittenden and the senator from Addison on the compassion that they've expressed for years on the topic. My question is very specific. I'm wondering if you're willing to offer any metrics on the success of these investments, considering we're now talking tens of millions of dollars and unlimited one-time funds. Basically to see, in particular, to see if we're on the right road for recovery or sobriety for those afflicted with the opioid issue. I just basically want to see if we're on the right path for making the investments which we made and the investments which we're proposing.
So thank you, Mr. President. Obviously, with the new addition of looking at outcomes-based decision-making and having those who have received the grants to give a report of their outcomes and the benefit, we're at a stage now where the money has been appropriated for just 1 year. So we'll be looking for the return on that investment, I think, going forward. And as this year goes forward, we'll be looking at the return on, actually it's 2 years, but we'll be looking at the return on the investment going forward. So it's an excellent question, and I think it's exactly why the language is in the bill that suggests we need to have data demonstrating that there's benefit to the appropriation of these funds.
So I thank the senator from Chittenden, and thank you, Mr. President.
The senator from Addison.
Thank you, Mr. President. I just would add that one of the priorities of the opioid settlement committee has been over the last 3 years, this is the third year of appropriations, has been harm reduction and saving lives as the main focus of where we're putting the money in these early years of getting the settlement money. And to the question from the senator of Rutland, I think that does actually show up in the data in that we have a declining number of deaths from opioid use over the last couple of years since we've started appropriating funds through the opioid settlement. I don't have the numbers in front of me, but I'm happy to get those for third reading.
Senator from Franklin.
Thanks, Mr. President. Look, the underlying bill on page 4, line 1, there appears to be a Scribner's error in the dollar amount that is shown. And I'm wondering, do we have an extra zero, or is the comma in the wrong place? Because it could be either $50,000 or $500,000, depending upon how you read it.
Great find. And so I am now looking at my fiscal note to offer what that is. Actually, so it is page 4, which line? Oh, the first line. So it's a judicial branch to train Vermont's judges. And just give me a minute while I find that in the fiscal note. Aha, so it is $50,000.
I'm very, very grateful.
We
Mr.
should
President.
move that decimal over. Thank you, Mr. President.
Thank you, Mr. President.
Okay. The Senate Secretary has informed me that this cannot be treated as a simple Scribner's error because it's from the House, but you, the Senate committee, can do an amendment tomorrow and correct it. Senator from
Mr.
Chittenden.
President, we will look at the number and bring a proposal of amendment to the Senate. This will be our second large amendment of this type. We did have an S, I think, in one, but thank you.
All right. Okay, so the question still is, shall the bill be read a third time, assuming that the amendment is going to make the correction tomorrow? Are you ready for the question? The question is, shall the bill be read a third time? All in favor, say aye. Aye. All opposed, nay. The ayes have it, and you have ordered third reading of H 218. We have on the calendar for action S 131. It was introduced on March 21st of 2025. It was referred to the Committee on Government Operation, which reports it has considered the bill and recommends that the bill be amended as it appears starting on page 927 of today's calendar, and that when so amended, the bill ought to pass. Listen to the second reading of the bill.
S 131, an act relating to approval of an amendment to the Charter of the City of Burlington relating to the possession of firearms.
I recognize the senator from Chittenden Central, Senator Vyhovsky, for the report of the Committee on Government Operations.
Thank you, Mr. President. S 131 is a charter change from the City of Burlington. A charter change that was first passed by the voters in Burlington in 2014, with at that time 68% of the voters supporting it. For reasons that I will not speculate on, democracy did not prevail in 2014, and that charter change was not taken up, even though it was approved by the voters of Burlington over a decade ago. Despite the fact that the city did not in fact need to revote this charter language to reintroduce it, they did so in March of 2025. And the charter has passed in 2025 with an overwhelming 86.6% of those voting supporting this change. It is clear that the voters of Burlington want the ability to create more safety in their city by eliminating guns in bars. As a child, at my very first firearms safety class, it was impressed upon me that guns and alcohol do not mix. A conversation that I've had again and again with friends and family, whether it be at the range or at another firearms safety course. As a social worker who also has an undergraduate degree in neuroscience, I know why guns and alcohol do not mix. There is no amount of alcohol consumption that does not impact our decision-making. Alcohol makes us more impulsive, more emotional, and more likely to act in ways that we might not if our inhibitions were not lowered because of alcohol. In fact, the US Department of Justice reports that nearly half of those who commit a homicide are under the influence of alcohol at the time they commit the crime. Burlington has unfortunately already experienced a tragedy because guns and alcohol simply do not mix. And I imagine this may have been part of the catalyst for them to renew their decades-long effort to take common sense public safety step of prohibiting firearms in bars. To be clear, this is not about taking people's guns away. This is about public safety and preventing predictable tragedies. Just like we don't allow open flames at gas stations or drunk driving on our roads, approving Burlington banning guns in places where alcohol is flowing and conflict can erupt in seconds just makes sense. As the language came to us in S-131, there was a question as to whether or not the language was too broadly worded and vague, as to where exactly it would apply, and so the committee members worked with Legislative Council and the city to tailor the language that you will find in your calendar to be clear where it applied and to meet the intent of the charter change and to be well within the bounds of the constitutional protections on the right to bear arms. Our most recent Supreme Court ruling on the Second Amendment was the United States Supreme Court's 2022 decision in the New York State Rifle and Pistol Associations versus Bruin. The government must justify a firearms regulation by demonstrating that it is consistent with national historic traditions of firearm regulation. The court in Bruin also held that there have been long-standing laws forbidding the carrying of firearms in certain locations that it deemed sensitive places, and therefore settled that these locations can enforce bans on firearms. The court identified 5 named sensitive places, though we know when we make a list, there can be things that are not on that list and can be included. Those places that they deemed sensitive are legislative assemblies, polling places, courthouses, schools, and government buildings. And with respect to sensitive places other than those 5, the question under Bruin is whether there is a historical tradition of regulating firearms in those locations, or whether the location is sufficiently analogous to one of the 5 recognized sensitive places to be constitutionally permissible. Fortunately, for the analysis of the Burlington Charter change proposed in S-131, that question has already been answered. With respect to bars and other places that serve alcohol, in October of 2024, in the case of Antoinette versus James, the United States Court of Appeals in the Second Circuit specifically held that regulating firearms in places that serve alcohol is consistent with the national tradition of firearms regulation and therefore is permissible under the Second Amendment. There are boundaries on all of our rights, just like you cannot yell fire in a crowded theater, and that is not a First Amendment violation. You cannot carry a gun into every place and have it be a second. You cannot carry a gun into every place, and that will not be a Second Amendment violation. Vermont already has laws that restrict firearm possessions in sensitive places such as courthouses, hospitals, and schools. Now let's talk about historical analogs. The prohibition of firearms in bars not only has historical analogs, but in fact there are many historical twins that have been cited in 2 recent court decisions like Antoinette that upheld the constitutionality of similar prohibitions in New York, California, and Hawaii. In 1853, New Mexico prohibited firearms at balls or fandangos and at any room adjoining said ball where liquors are sold. In 1870, San Antonio, Texas banned firearms in any bar room or drinking saloon. In 1879, New Orleans banned firearms at any public hall or tavern. In 1889, Arizona required that the keepers of drinking saloons keep posted in a conspicuous place in his bar room a plain notice that travelers are to divest themselves of their weapons. And in 1890, Oklahoma banned firearms at any place where intoxicating liquors are sold. So I think we can all agree this is not a new idea. Additionally, there are currently 15 states that have some type of firearm prohibition in bars, including Texas, Kentucky, and New York, whose total prohibition was upheld as unconstitutional in the Second Circuit, which is the same circuit that Vermont is in October of 2024. Now let's turn to the language in front of you, which can be found on page 927 of your calendar. Your Committee on Government Operations is proposing an amendment that makes the following changes to align with the constitutional protections of the Second Amendment and the public safety intent of the voters in the city of Burlington. Section 1, this is boilerplate charter language used to approve the charter change of the city of Burlington, which again was voted on March 4th, 2025 with an overwhelming 86.6% of the voters voting in support of the change. Section 2, subsection A. This specifically supersedes 24 VSA subsection 2291 and 2295 and authorizes the city to regulate the carrying of firearms as it is laid out in the bill. And subsection B prohibits the knowing, and this part's really important, possession of firearms in establishments licensed to serve alcohol. The knowingly standard is a standard set in law that means it must be proven that the person both knew they had a gun and were in a bar. S-131 applies to first-class licenses. This is establishments serving malt beverages and vinous beverages, ciders, and ready-to-drink spirit beverages. Third-class licenses, establishments serving spirits and fortified wines. Fourth-class licenses, which are manufacturing locations where limited volumes of beverages are served for on-premise consumption. Outside consumption permits, this would be, say, a restaurant patio or a bar patio. Clubs and fraternal orders, and sampling event permits. This would apply to festivals such as Brewfest, where the primary purpose of the event is to serve alcoholic beverages. Subsection C begins to enumerate the exceptions to the prohibition. In the subsection, there's a different word for that, is the place exceptions. These are the places that are accepted from the prohibition, and this includes second-class licenses, including those with a temporary tasting license. So this is your retail alcohol sellers, your gas stations, your grocery stores, your 802 spirits, even if they have a special permit to do a tasting on site. Subsection B, sidewalks and streets that pass through a patio with a license to serve alcohol for on-site consumption. This language is to make it crystal clear that the patio prohibition does not spill out into the street or onto the sidewalk. Subsection C, a premise for which a licensee holds a limited event permit. Festivals, and this would be festivals and other events where alcohol might be served, but is not dedicated to serving alcohol. Events like Jazz Fest. Special event permits, things like stalls and pop-up locations embedded within an identifiable event, perhaps a brewer's tent or a tailored or a food truck event, or special event serving permits, special event service, oh, that's a repeat, never mind. This is where a manufacturer might serve samples by the glass or in an unopened container, or the special venue servicing permit, which might be an art gallery or a retail establishment or a public library that's hosting a one-time event that might include alcohol. Subsection D, a dining car for which a licensee holds a promotional railroad tasting permit. Some of you might be going to one of these dining cars later today. This does not apply to a dining car that holds its own first or third class license, like some dinner trains might in the Burlington area. This next subsection begins the people who are exempt. Any federal, state, or local law enforcement officer acting within the scope of that officer's official duties, any member of the armed forces of the United States or the Vermont National Guard acting within the scope of that person's military duties, any government officer, agent, or employee authorized to carry a weapon and acting within the scope of that person's duties, the holder of the license for the premise, provided that person is not prohibited from possessing or carrying that weapon under any other federal, state, or local law, The next section sets the penalties. The penalties for any violation of this section shall be as follows. It may be a criminal offense. Any violation of this section may be considered a criminal offense, which is not punishable by a fine of not more than $1,000 or imprisonment for not more than 90 days. It could also be a civil offense. A violation may also be considered an offense to the civil ordinance, punishable by a civil penalty of not less than $200 and not more than $500. You will note that missing from the original bill is the additional penalty of a civil forfeiture of the firearm. After discussion with the city and legislative council, we felt that this should be removed from the bill. And removing it will not hamper police's ability to remove the firearm at the point of the crime of carrying it into a bar, but it solves a potentially overly burdensome penalty and the potential permanent removal of the courts of the firearm. This act shall be effective on passage. We heard from legislative council, the president and executive director of the Vermont Federation of Sportsmen's Clubs, the city attorney from the city of Burlington, the interim police chief from the city of Burlington, the senior litigation attorney and second amendment issue manager at Giffords Law Center to prevent gun violence, the president of Gun Owners of Vermont, the owner of T. Rugg's Tavern in Burlington, another legislative council attorney, and the mayor of Burlington. As a reminder, the city of Burlington voted on this charter change and voted to support it in 2014 with a vote of 5,194 to 2,437, and in 2025 with a vote of 8,335 to 1,284. While we are a Dillon's Rule state and the legislature is responsible for approving charters, it is simply bad democracy to stand in the way of what the voters are asking us for. Unless this proposal is blatantly unconstitutional, and this is not, or blatantly discriminatory, and this is not, I have personally voted for charters that I do not agree with. Charters that I would have voted no on as an individual citizen, because my role in the Senate on a charter is not to let my opinion prohibit the democratic process for the people that I represent or any Vermonter, but to ensure that the charters meet legal requirements and do what they are intended to do. And this is exactly what was done with this charter when we worked to narrow its scope and meet the intent of the city of Burlington. The city has been waiting for over a decade for the legislature to affirm their vote and stand up for democracy and the will of the voters in Burlington. The vote today is not about whether or not you agree with the prohibition of guns in bars. That is not the question before you today. The question is, do you believe in local control? Do you believe in democracy and the right of those who live in Burlington to use the democratic tools available to them to chart their path forward towards public safety and security? Or are those just words we say when we don't want to do something at the state level? Your Government Operations Committee voted 3-0, and we ask for the Senate to concur.
The question is, shall the bill be amended as recommended by the Committee on Government Operations? Are you ready for the question? Senator from Rutland.
Thank you, Mr. President. I rise in opposition to Bill S-131. Purpose of S-131 is to circumvent the intent of Vermont's preemption statute regulating firearms. Vermont is a Dillon Rule state, which means that local governments are creatures of the state and are created and governed by state laws, meaning they're ultimately dependent on the state for their authority. 24 VSA 2295 prohibits one city dictating to the rest of the state how firearms could be regulated, avoiding a patchwork of different rules to manage firearm regulations within the state, that they are equally applied throughout the state. S-31 is a direct violation of the state's preemption statute. S-31 may be lawful only if passed by the legislature, but it certainly is illegal today because our preemption law exists and it forbids what it proposes. By using what appears to be a loophole in the preamble of the existing preemption statute, which states, except as otherwise provided by law, we're being asked to support a bill that's illegal. I guess, in a technical sense, violates current law for sure, all in the hope that it will pass in this body. then in the other body, and finally be signed by the governor. I feel that I'm breaking the law by violating my oath of office, so the one town can violate the Vermont preemption statute, which specifically prohibits what S31 wants to do. This doesn't make any sense to me. So I suggest that S131 be referred back to Senate Government Operations Committee for further consideration. And if the committee chooses not to take it back for more detailed consideration, I make the motion that the order of this bill be ordered to law. May I interrogate the reporter of the bill?
The reporter,
Point of procedure, Mr. President.
yes, Senator from
I'm wondering,
Chittenden.
the senator did make a motion. Should we vote on that motion prior to further discussion?
So debate is allowed while the question of moving it back to committee is pending.
May I further inquire, would the senator's interrogation then be limited to the question of whether it should be ordered to lie or go to the specifics of the bill?
The first motion was actually to move it back to the Committee on Government Operations, I believe.
Correct.
So that would be the motion that debate is under.
And so debate would be tailored to that question, am I right?
That's the question, and debate should be tailored to that question.
Thank you very much, Mr. President.
Point of information.
What is your point of information?
May I just have an explanation of a motion to move to committee, how many votes are needed? And is that an automatic roll call vote? What's the process for a motion to refer to a committee? And I believe I heard the senator say Senate Government Operations, but I didn't catch that.
It's simple majority.
Okay, a simple majority to have it recommitted.
Yep.
And did the senator want it sent back to Government Operations? Was that what?
That is the motion on the floor as I understand it.
Thank you.
Senator from Franklin, do you have a point of order?
I do. I have a request for a point of information.
What is your request?
And that is, would it be proper if the senator from Rutland desired to question on a wider scope for him to withdraw his motion that is pending on the floor right now and then simply ask to speak on the question, the underlying question?
Yes. Senator from Rutland, if you do want to interrogate the reporter of the bill on the entire bill, I would suggest that you withdraw your motion until after your interrogation.
Without objection.
The senator who reported the bill, Senator Vyhovsky, is interrogated.
So this bill exempts itself from 24 VSA 2291 and 24 VSA 2295. I see, however, that S131 provides both a civil penalty and a criminal penalty. Having both a criminal and civil penalty does not appear to conform to 24 VSA 1971, which states that no municipality ordinance can contain both.
I may need a moment to confer with legislative counsel.
I would ask for a moment's recess.
Brief recess. Will the Senate please come to order?
Thank you, Mr.
The
President.
interrogation may continue.
Thank you, Mr. President. That is accurate that no city may adopt an ordinance that contains both a civil and criminal penalty, but that's not what we're doing here. The city is not adopting an ordinance. The legislature is adopting into charter this language. And there is no prohibition on the legislature setting both civil and criminal penalties.
So, Mr. President, the 24 VSA 1971 prohibits a municipality from doing that. And my next question is, was this brought up in committee?
The municipality is not adopting an ordinance under 17, I don't know, I can't remember what you just quoted to me, but what that pertains to is the city adopting an ordinance. The city is not adopting an ordinance. The General Assembly is adopting language into the charter of the city of Burlington. This is a law that we are passing, not an ordinance the city is passing.
So without expressly stating that S-131 exempts itself from 24 VSA 1971, how's this ordinance legal for existing state law?
Because this is not the municipality adopting an ordinance, this is the General Assembly adopting legislation into the charter of the city of Burlington.
I thank the reporter of the bill. So if I may, I want to change my motion that we withdraw and move it back to Judiciary Committee. And if they don't want to take it up, then have it ordered to lie.
We will do one motion at a time, Senator. And so the motion on the floor is the senator from Rutland has moved that the bill be committed to the Committee on Judiciary. Are you ready for the question? Senator from Windham.
Mr. President, I am reflecting on a conversation that was had about a year ago in Senate Education, where we were talking about not even a charter change, we were talking about prohibition of firearms in libraries. And I recall going to the late Senator Sears to get his advice on whether or not we would be taking that bill. And in his own colorful way, respectfully declined the opportunity to take on that bill. In this case, this is a charter change that I understand is within the jurisdiction of the Government Operations Committee. I did take my own personal look at this bill and went back and forth as to whether or not we, as a committee, needed to take a look at it, or rather have jurisdiction of it. I will say that tomorrow we are taking a informal look at the bill to determine if there's any sort of change that needs to be made. But in my opinion, we do not need jurisdiction, or we don't need the bill formally committed to our committee. So I would ask this body to vote no on this motion, as I don't believe that Senate Judiciary formally needs to have the bill committed to us.
Are you ready for the question? Senator from Grand Isle.
Thank you, Mr. President. May I interrogate the senator from Chittenden?
The senator from Chittenden is interrogated as the reporter of the bill.
Mr. President, point of procedure again. Will this interrogation be limited to the question of moving it to judiciary?
I would ask the senator from Grand Isle if he wants to wait until
Perhaps
after
I
this
stood up
vote.
a little prematurely. I will sit down and wait for that.
Thank you,
to
Mr.
happen.
President.
Thank you, Senator. Are you ready for the question? The question is, shall the bill be committed to the Committee on Judiciary? Senator from Chittenden.
And I will be brief. I would say 11 years is long enough. We do not need this bill moved formally to judiciary. So I would counsel everyone who supports the bill to vote no. Thank you, Mr. President.
Are you ready for the question? If so, all in favor say aye. All opposed, nay?
Nay.
Motion fails. The question now is, are you ready for the question? Senator from Grand Isle.
Second time around is better, Mr. President. May I interrogate the senator?
Senator from Chittenden Central is interrogated.
Mr. President, you spoke of initially an 86% of voter turnout supported the charter change.
86.6% of the voters who voted in 2025 supported this charter change.
Okay. Could you tell me what the percentage of voters, registered voters voting were?
It was just a little under 34%.
So we're talking 86.6% of 34% of the voters.
Yes, which is fairly high for a town meeting vote.
Okay. A little question about reading the bill. I see where there's an exemption for sidewalks separating a restaurant bar from a sidewalk expansion type roped off area, I guess.
There is an explicit statement that public sidewalks that pass through. So if you think about Church Street, there's plenty of bars. The one that immediately pops into my mind is Reraw, where there's an interior section, and then there's a sidewalk, and then there's a roped off patio section. That sidewalk that goes past the patio and past the entrance to the bar is not included in the prohibition. And that is likely true without this language, but we wanted to be crystal clear that that was not going to be included.
Very good. And the actual roped off area would not be exempt. Correct?
That is correct.
That's correct. Signage, I looked in the bill for signage. How would one know, since we're currently a Dillon's Rule state and until this bill passes, a traveler or even somebody from down southern Vermont traveling to Burlington, how would one know that they were violating state law if they walked into a restaurant carrying a firearm?
The charter doesn't require specific signage. That's left flexible to bar owners to instruct patrons in a manner that works best, either orally or through signage. I'd expect many establishments may put up signs, as some of them already do.
There's no requirement.
There is no requirement.
I can see. Okay. Let's see, I have a few questions. On the point with the criminal and the civil penalty, I don't really want to revisit that totally, but once it's in statute, once it's in the charter, how does one, the offense seems to be the same, but it's at the discretion of who to create a criminal or civil offense?
That would be up to the discretion of the state's attorney who's charging the crime.
Okay, the fact that it's just an aside note, I'll comment on that. The fact that there's a criminal offense involved, to me, really underscores the need to go to judiciary, but that's another, they're going to take a look at it. I guess I'm okay with that, but I really think it should go there. How about someone renting a room at I'll use the Hilton in Burlington, since that's where we are, and has no desire to attend the bar, have a drink or anything like that, but they're in an establishment that has a bar or serves liquor. Would they be exempt, or would they fall under this?
It's possible that they could, but the knowingly standard might also apply in this instance, as the knowingly standard does require that the individual knows that they are at a bar.
Okay, but they wouldn't know that if they were traveling from out of state without any signage.
If they don't know that, if it can't be proven that they knew they were at a bar, then they would not be subject to the criminal penalty.
And that would be up to the discretion of the arresting or the investigating officer?
The
at the time or
proof,
the DA?
the proof of the knowingly standard would be up to the state to prove in court.
Okay. In an instance where, I guess, a license holder is exempt, the licensee of the establishment would be exempt. In the case of, I apologize because I may know the answer to this, I'm thinking I know the answer, but in the case of multiple owners or an LLC that might own an establishment, say we have 3 partners in a bar, all 3 can carry?
If all 3 of them are the license holders, then yes, they would all fall under the exemption.
Thank you. Was there any testimony taken as to whether parts of this bill are in current litigation in the Supreme Court?
We did not take any testimony to that fact.
Okay, I might want to talk about that tomorrow briefly, but I don't have a lot of information on that right now. One final question. Any examples or of any violations or shootings that have happened in a bar in Burlington in the last 20 years?
I did not do a review of every criminal instance that's happened in bars in Burlington, so I am not sure if that has happened in the last 20 years.
You know of any? No.
I didn't do a deep dive into, so I don't know if that has happened in the last 20 years.
Thank you, Mr. President. That's the questions I have for today. I'm concerned about a lot of aspects of this bill, not to mention the fact that it's going to be, we're going to have, Dillon's rule goes away. I mean, this is going to create a patchwork of firearms laws, and it could trickle down to other items, other things throughout the state. Unpredictable. I'm worried about signage. I'm worried about the traveling public not knowing. I'm worried about our own citizens from throughout the state not knowing about this regulation. I'm worried about what happens when they do, when they are stopped at the door or in a restaurant with a firearm. And I'm really worried about how we enforce this. I guess, I mean, the only way I can see to enforce this would be to reinvigorate the stop and frisk law, which I think most of us in this room would not appreciate. So I don't know how you enforce it. I don't know if we're requiring metal detectors at the doors of every establishment in Burlington. I doubt it. And I worry about my ability and the ability of every other Vermonter. I grew up in Burlington. Let me say this. I walked 2 miles every day in 2nd and 3rd and 4th grade to my grandmother's. Would I do that now? Would I be allowed to do that now? No. Things have changed. Things have changed everywhere, so I'm not singling out Burlington. But I worry, I do go down to Burlington, downtown, out to dinner. Sometimes it's a parking garage, which is not one of the best places to be at night these days. And it's a 2-block walk to the restaurant in most instances. I worry about not being in the restaurant eating dinner. I worry about how I'm going to get there safely with my wife, my grandkids, and so forth. So this concerns me. People may know, do carry occasionally, and especially when I'm in downtown Burlington. To get from the car to a restaurant it can be very dangerous. And I can't support this bill. I do wish it would have been referred to judiciary. I actually wish it'd be ordered to lie, but I don't see that happening either. I would just urge my colleagues to vote no on this bill. Thank you.
Senator from Chittenden.
Thank you, Mr. President. Burlington has seen an incredible rise in gun crimes. The idea that more guns make us safer, there is simply no data that supports this. The United States is by far the most armed country in the world, and yet we are 132nd out of 163rd in the global safety rating on the Global Peace Index in 2024. We have fallen yet again in the rankings for safety. We do have the most mass shootings of any country in the world, the most gun deaths in the developed world outside of an active war zone. 8% of the deaths in the United States are gun-related. We do have the highest rate of children dying because of guns, the most gun violence. In 2023, nearly 47,000 Americans died due to guns. And this is only for those for whom the gunshot was the sole cause of death and not just a contributing factor. There is not a single data point that shows us that having more guns keeps people safer.
Senator from Rutland.
May I interrogate the reporter of the bill?
The reporter of the bill is interrogated.
So to give you a hypothetical situation, I'm from Pulteney and I go to Burlington and I usually carry a firearm. And I go into a bar, I don't know that this ordinance exists, but I find out about it. I've driven 2 hours to get to Burlington. If I leave my firearm in my vehicle and somebody breaks into it and steals it, I'm in violation of that too. So how do you recommend that I get around that law that we just passed?
The message for people going into establishments serving alcohol in Burlington is fairly simple. Trigger, lock your firearm, and leave it in your locked car. If the questioner would like to offer a substitute amendment that makes this a statewide ban on firearms in bars to be more clear and less confusing, I am sure the committee would consider that as an alternative.
Thank you, Mr. President. So in closing, I just want to say that this bill, if we vote for this and it passes, then we're violating our oath of office because the premise of this S-131 is unconstitutional. Thank you, Mr. President.
Senator from Chittenden.
Thank you, Mr. President. I want to begin by thanking the committee. A gun bill is never an easy thing to move through committee. And I appreciate very much the measured and thoughtful way that the chair and the committee took this up. I also appreciate the amendments that were made to it. The drafting that came out of Burlington had some, I think, arguably unconstitutional elements. As described by Eric Fitzpatrick from Ledge Council, they were unconstitutionally broad and vague. The committee did exceptionally close, I would say surgical work on that. And what they have come out with, from all the opinions we've been able to gather, is constitutional and firmly so. With that said, I want to just ask people to think about the situation in Burlington over the last few years. I am positive that every senator in this chamber has had a conversation, usually with a sort of isn't that too bad tone in their voice, what's happened to Burlington, right? I don't feel safe going there when my grandkids come out of town. I don't feel safe taking my family for dinner there. We who represent Burlington have heard these conversations on the campaign trail. We heard them, we spoke to them, we answered people's questions. We were asked at a forum, do we still go downtown in Burlington at night? And all of us laughed and said, absolutely we do. Now, what I want to say is Burlington is experiencing challenges, and gun violence is one of them. We are also experiencing challenges with homelessness and with opiate addiction. And as a result, the Judiciary Committee, over the last couple of bienniums, has added legislation to deal with shoplifting, retail theft, opiate addiction, and the violence resulting from that. So the governor has pushed each year a public safety bill, and our chair in Judiciary right now is working on, in part, a template from the governor's office to help improve public safety in our largest municipality. With that said, it is a complete disconnect for me for folks to decry violence in Burlington, to decry the shooting that led to the death of a man outside Red Square, a man who bled out on Church Street and died, at the same time to say, but action by Burlington voters, nearly 90% of voters who turned out to control gun violence is beyond the pale. So you can't have it both ways. If we're going to be safer in Burlington, and there's nobody who wants that more than me, if we're going to be safe in Burlington, it has to be through a combination of measures, and it has to be all parties, and it has to be moving sometimes in directions that may make people slightly uncomfortable. So you will remember that we passed measures to deal with the opioid crisis last year. We passed measures to increase penalties, but also to increase the available treatment options. So we are all finding our new comfort zone. I would just suggest, if you came into this chamber today planning to vote no, briefly rethink. Should we be asking Burlington and demanding that they make their streets safer so that all of us can use our largest city and have recreational opportunities there? Is it fair to ask that of Burlington and then to tell 90% of voters, or nearly 90%, we're sorry, we're going to order your charter change to lie, or we're going to order your charter change to once again be killed in committee, which is what happened 11 years ago. So we have a chance to right that procedural wrong, and I think we should do so absolutely without delay. Chair of Judiciary has said we will take a look at the criminal penalties tomorrow. He does not believe, and I do not believe at this point, that there's anything wrong with those penalties, but we will double check tomorrow. So with that said, Mr. President, I would ask that senators vote yes and vote no on any proposition that would delay that vote. Thank you.
Are you ready for the question? Senator from Essex.
Thank you, Mr. President. The only time that I carry a firearm is when I'm in Burlington. If you know I'm in Burlington, you know I'm carrying a firearm. Doesn't matter where it is, you've seen me there. I don't brag about it. I don't display it. I do it for my own safety, as do actually most people that I know. Go to Burlington, they carry a firearm. You don't know it, but they're there, and they're there because they don't feel safe. Gun violence in Burlington isn't caused by me, isn't caused by any of my friends, isn't caused by anybody that I know that's gone there to try to do business there, to go to a restaurant, to do some shopping, to do whatever. I think we know why the gun violence is there and who's perpetrating it. I can tell you that I will not be able to go to Burlington anymore. That'll probably make some of you happy. But this law passes. I will not be able to go to Burlington in good conscience. I won't be able to take any of the family members into Burlington in good conscience. And I apologize to the city of Burlington for that. But I'm not going to go someplace where it's constitutionally my right to keep myself safe and then go there where they want to infringe on that. And I would never forgive myself if I was in a situation to where I would have had to have done something to protect myself, and I was there. Basically, it's going to a knife fight. It's going to a gunfight, bringing a knife. I just wouldn't be able to do that. So, in good conscience, I'm sorry for Burlington that I got to tell you that I can't go there and do business anymore should this pass. And I don't think it's going to be just me. I think it's going to be a lot of people who are law-abiding citizens who always want to do the right thing. They're not bringing a gun to start a gunfight. They're bringing themselves to prevent themselves from getting in a gunfight or getting themselves from being injured. And I won't be able to go there any longer if this passes. Thank you, Mr. President.
Are you ready for the question? Senator from Chittenden.
Thank you, Mr. President. With deep respect to my good colleague, the senator from Grand Isle, I'd like to return to the scenario that he laid out, and particularly saying how frequently he was worried. He'd be worried about going to Burlington. He'd be worried about walking down the street. He'd be worried about going out to dinner. And I just want to highlight that when somebody drives with their wife and their grandkids out to dinner in Burlington, we hold them to a very different standard getting back into their vehicle if they have had something to drink. I would imagine, and we are a gun-owning household. I don't live in Burlington any longer. People remind me of that a lot, but I represented Burlington as a legislator living in Burlington for 8 years, and I still represent it now. And we are a gun-owning household. We have kids, and I would treat my husband to a very different standard if he was holding a gun after he had had an alcoholic beverage than before. Most people in Burlington and beyond, I think, would agree, responsible gun owners included, that you should be held to a very different standard around your wife and your grandkids, whether you're getting in a vehicle or taking out a firearm, if you have had something to drink. Mr. President, I was there in the House when this charter change came up, along with a suite of charter changes. I was actually working for the city of Burlington as well, so was very intimately familiar with these. And a very prominent leader in the House in a private meeting trying to advance some of these provisions said, you know, Burlington's not that unsafe. That is seared in my memory, and it's been seared in my memory every time we have another incident of gun violence in Burlington. I took my kids and their nanny to Church Street the day after the shooting. I wanted to try and show our nanny, who's on an exchange program from Rio de Janeiro, Brazil, that she could still have fun and be safe on Church Street. But I was very cognizant of the yellow tape, of the stains that were still on Church Street, and making sure that we waited an extra hour for her friend to come and meet her. And we checked in on her, and you can imagine, we were really worried about her that night. And she's in her 20s. When this charter change came up 11 years ago, yes, somebody in an open crowd in front of Nectar's started openly shooting after a dispute with another patron of Nectar's. And the bullet hit the chest of a student who was in critical care in UVM Medical Center. That reverberated across the entire campus with a lot of people we might be worried about as students or the traveling public or the visitors that we have to our communities. People who expect to feel safe when they go out for a night on the town. Mr. President, I really think it needs to be said, for those who now don't know whether or not they can come to Burlington, 86.6% of people in Burlington can rarely agree on anything. And for that high of a percentage to agree that they would feel safer in their community if people did not have firearms in their possession late at night, downtown, in the bar scene, frankly, including situations that have gotten worse and worse for law enforcement, to the point that there have been questions in Burlington about whether or not law enforcement feels safe without drastic numbers being present on Church Street after 10 p.m. So we often like to say that Burlington is so nice because it's close to Vermont, until Burlington actually wants to do something to say, we are having a little bit of a different experience than the rest of the state right now. We are the place that many people from many corners come for various reasons. And as the student body president at UVM, when Michelle Gardner Quinn was killed, we had a lot of conversations about being a place where predators come to bars to find young women. That is not the reputation that we want to have, Mr. President. And so I would ask us to make sure we are as worried about the people who actually enter those bars late at night, the people who own those bars, the law enforcement that go to late night chaotic scenes on Church Street, as we are about ourselves going out to dinner at 8 p.m. Mr. President, I would just end by saying this could just as easily be a matter for economic development or health and welfare. We have had so many business owners, so many people traumatized by what's been happening in and around Church Street in Burlington. We have had so many people tell us they're no longer coming to our downtown. And they don't feel safe walking from a parking garage to the downtown. They don't feel safe after a certain time. They can't get a taxi home. It has been 11 years that we've been having this conversation. That to me demonstrates a deep respect for the Sportsman's Bill of Rights. And a situation that is so out of control that when we first started talking about this, it went from, there's not that big of a safety problem in Burlington to, I don't want to take my kids and grandkids down the street without a gun. So, Mr. President, I would truly ask the members of this body to finally respect the wishes of a community that feels under siege and let them have this charter change and do our due diligence. Thank you, Mr. President.
Are you ready for the question?
Roll call.
Senator, roll call has been requested, and when the vote is taken, it'll be taken by roll. Senator from Grand Isle.
Thank you, Mr. President. I skipped one or two questions, if I may.
The
Before I do
reporter of the
that.
bill is interrogated.
Well, I wasn't finished.
Oh, I'm sorry.
Before I do that, I'd like to assure the other member from Chittenden, I don't know what section of Chittenden.
Southeast.
Southeast, with the utmost respect that I have for her, that maybe I gave the perception that I was hauling off my wife and grandkids down to the local bar in Burlington. That's not what I'm talking about. I'm talking about going out to dinner and in a peaceful, probably non-alcoholic atmosphere with the kids. So that's what I'm concerned about. And with that said, I would like to ask a couple more questions of the senator from
The senator from Chittenden Central is interrogated.
On my emails this morning, I was contacted by a local lodge such as there was an Elks. You've got Legions, you've got Elks, you've got all these animal clubs out there. And some, I see in the exemption section that some of that, there's an exemption for special events. And I'm wondering if that pertains to say the Boy Scouts renting the hall. It wouldn't be the Boy Scouts in this case because they would be serving alcohol most likely. But a special event in the back room, totally separate from the Elks Members Lodge, but they're in the same establishment, same building. Do I read that as being exempt?
I don't believe that that would be exempt because the club, if the club has a first-class license or is able to serve.
Okay, I'd have to refer back to that section of the bill here for a second, if you could bear with me. The premises for which a licensee holds a limited event permit, special event permit, or special event serving permit. So that would have to be not related or attached to any establishment serving alcohol with a license?
So those clubs that you're referring to, the societies, fraternal orders, this prohibition does apply to. The special event permits that you're referring to would be like if you went to the farmer's market and there was a brewer's tent.
So, okay, so I would understand that. I don't know if they still have it, but the Brewers Festival on the lake, which serves, has a special permit to serve alcohol, you were allowed to carry down there?
No, those have a different type of permit. It's called a sampling event permit, which is clearly laid out as in the prohibitions. And so if it's a festival such as Brewfest, where the primary purpose of the license is the service of alcoholic beverages, the prohibition does apply.
Okay. One final question, and thanks for your patience. Did the committee talk about enforcement at all, as far as, and I hate to keep harping on signage, but how do you expect law enforcement or bars, restaurants, hotels to enforce this bill?
We don't actually expect bars or hotels to enforce this. We expect this to be a tool by which they can ask law enforcement to enforce it, much like we do with the rest of our laws. And we did hear from the chief of police in Burlington, who is in support of this language, that when they are going into situations where alcohol is involved, I believe his words were, fewer guns are always better.
Okay, so the only way that they would be reported to law enforcement would be if they walked in and, like, a gunslinger hanging an open carry 45 on his hip, I would guess, because if it was a concealed carry by the person, how would anybody know?
They probably wouldn't. And generally speaking, sociological research shows that when we pass laws, the majority of people will follow them, and some people will not. What was asked for from bar owners in Burlington, we even had one of them come in, was that they be granted this tool to be able to engage law enforcement for individuals who refuse to follow a citywide ban.
Thank you, Mr. President. Thank you, Senator. I think she hit it, the senator from Chittenden hit it pretty much on the head. What you'll have here with this bill passed is law-abiding citizens who currently may feel the need to carry in Burlington follow the law. I will, and I think every other law-abiding citizen will. The people who won't, I think we all know who they are, and they don't care what laws we pass here in Montpelier. They're going to carry regardless. And that scares me. Senator, they're all from Chittenden, it seems. Senator from Chittenden, East, I guess, again, he mentioned being uncomfortable. I'm okay with being uncomfortable. I'm not okay with being unsafe, feeling unsafe. Uncomfortable I deal with every day. I'm up here talking. I'm uncomfortable. So these issues bother me, along with, I think of the incidents that have happened in Burlington. Waitresses leaving, a good friend of mine, wife leaving the restaurant, not a bar. Well, I guess you could call it a bar too, but it's a restaurant, late at night, accosted by a person who basically attacked her. She got away. 2 o'clock in the morning, closing a bar, I would train my wife to be armed, I would train her to protect herself. The guy who's going around with thousands of dollars at night replenishing ATMs on Church Street, Burlington, and late at night, I think they're armed currently, but this would prohibit them if they were to walk into an establishment and replenish an ATM. These things worry me, and I think we're creating a soft target. We've seen many school shootings. They're horrible, they're horrific, but this is adding another soft target to the list. And I'm concerned, and I will again be not supporting this bill.
Senator from Windsor.
Thank you, Mr. President. I'd just like to remind the senators that this is a vote to support local control and that there is nothing in this charter change that prevents concealed carry in Burlington. Thank you.
Senator from Rutland.
Thank you, Mr. President. May I interrogate the reporter?
Point of order.
Senator from Rutland, are you requesting to speak a third time?
I can try.
Senator from Chittenden.
Thank you, Mr. President. I want to just quickly speak to the enforcement piece. I have argued many gun safety bills on this floor. Every single time, we've had the exact same discussion, and the answer is always the same, which is when we pass a law, as was pointed out by my colleague, we count on people to follow the law, and most people do. Is there 100% compliance to any law? Almost never. The other piece that I would say is we did several years ago, we made it illegal in the state of Vermont to carry a gun into a hospital. And we had the exact same question about how will this be enforced? Is a doctor in the middle of a surgery going to be forced to go relieve someone of a weapon? And the answer is no, of course not. What it means is that hospitals don't get into an argument about Second Amendment rights anymore. They call the police come, and they say there is a state law prohibiting this. In this case, we have a Burlington deputy police chief who has said, please pass this, we will enforce it. So I understand that arguments, spring eternal, but the answers to them are always the same. We've had no trouble enforcing our law against guns in hospitals, and I don't believe we'll have additional trouble in our bars in Burlington. It will be a tool to help us call the state police and to empower them. Thank you, Mr. President.
Are you ready for the question? The question is, shall the bill be amended as recommended by the Committee on Government Operations? All in favor, say aye. Whoop, roll call, sorry. The secretary will commence to call the roll.
Okay. Should the bell be rung?
Bells are ringing.
Senator Brew,
Yes.
Senator Beck,
No.
Senator Bongard,
Yes.
Senator Brennan,
No.
Senator Brock,
No.
Senator Chittenden,
Yes.
Senator Clarkson,
Yes.
Senator Collmore,
No.
Senator Cummings,
Yes.
Senator Douglas,
No.
Senator Bewley,
Yes.
Senator Hardy,
Yes.
Senator Harrison,
Yes.
Senator Hart,
No.
Senator Hashim,
Yes.
Senator Heffernan, Senator Ingle,
No.
Senator Lyon,
Yes.
Senator Major,
Yes.
Senator Matos,
No.
Senator Norris,
No.
Senator Pershler,
Yes.
Senator Plunkett,
Yes.
Senator Ron Hinsdale,
Yes.
Senator Bohosky,
Yes.
Senator Watson,
Yes.
Senator Weeks,
No.
Senator Westman,
No.
Senator White,
Yes.
Senator Williams,
No.
Senator Heffernan,
The yeas 17 and the nays 12. And you have amended the bill as recommended by the Committee on Government Operations. The question now is, shall the bill be read a third time? Are you ready for the question? If so, all in favor, say aye.
Aye.
All opposed, nay.
Nay.
The ayes appear to have it. The ayes do have it, and you have ordered third reading of S131. I thought we were passing over that. I assume we're passing over 28. That completes the orders of the day. Senator from Chittenden.
I rise with both an announcement and a statement of personal privilege. So the announcement is, I forgot earlier, there's a cake out there. It is for Senator Clarkson for her birthday, Mr. President. But also Senator Norris had a birthday this week and everybody else had birthdays and it's decorated like Vermont. So I hope everybody has a little bit of cake and especially celebrating our Senator Clarkson. And my lovely spouse made it with my 3 kids who are on break this week. I should give proper credit due. I don't bake, but they love baking and so they love Allison Clarkson as well. So they were happy to bake that. All right, and now my statement, point of personal privilege. Mr. President, may the times we inherit be interesting and worthy of the historical record. These times certainly are that, and I rise with this statement because of how interesting these times certainly are. I do not rise seeking the spotlight, nor to score political points, nor do I rise to cast shade or stone. There is enough of that in the world today. I rise today because of concerns with actions in this country fostering ill will and diminishing our standing in the world. I rise today because 2 days ago in this building, I ran into a former colleague who I hadn't seen in a while. I used to work with him. In the 4 years I knew him, his cultural heritage and citizenship had never come up in conversation. But this time he said to me, "Tom, I am no longer welcome here. I am Palestinian, and this country does not want me here." I saw in his eyes not fear, not hatred, not disappointment, but realism. I saw in his eyes a resignation that this country is no longer what it was to him. That is why I rise today, Mr. President. I said to my friend that I want him here, and that I want his family here, and that we have always been a country of immigrants made stronger with our diversity of background and heritage. I told him that I am sorry. I grew up in the 80s, and I grew up a Republican. Most of my family still are Republicans. These days, I'm a bit of a black sheep at family parties. I offer this because I want to close with a quote from a famous Republican who often spoke of America as the shining city upon the hill. This is from his farewell to the nation that he offered back in 1989, and his words ring as true today as they did then. Quote, "I've spoken of the shining city all my political life, but I don't know if I've ever quite communicated what I saw when I said it. But in my mind, it was a tall, proud city built on rocks, stronger than oceans, windswept, God-blessed, and teeming with people of all kinds, living in harmony and peace. A city with free ports that hummed with commerce and creativity. And if there had to be city walls, the walls had doors, and the doors were open to anyone with the will and the heart to get here. That's how I saw it, and I see it still." Ronald Reagan. That is the America I want to see in the world today, and it is how I hope my friend one day sees America again. Thank you, Mr. President.
Are there any further announcements? Senator from Windsor.
Mr. President, I would make a motion that we journalize the remarks by the senator from Chittenden.
Senator from Windsor has moved that the remarks of the senator from Chittenden Southeast be journalized. Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and we've moved to journalize the remarks of the Chittenden Southeast senator. Senator from Franklin.
Thank you, Mr. President. I'd like to speak to a point of personal privilege, and that is to amplify the remarks of the senator from Chittenden Southeast, but to modify that to reflect that this is not an issue of partisan politics, and that Republicans, particularly Vermont Republicans, who've always been different, perhaps, than Republicans in some other places, have always kept a door open for everyone, regardless of where they're from or who they are or what their background is. And I think that is something that, as we reflect some of the situations happening in our country today, they don't necessarily represent Vermont Republicans. Thank you, Mr. President.
Are there any further announcements? Senator from Windsor.
I guess there are no committees meeting this afternoon, Mr. President.
How nice.
My heart is so full. Excuse me, sorry, we'll start again. Sorry, 70, I need the glasses, what can I say? My heart is so full, such articulate colleagues, Many thanks, dear friends.
Are there further announcements? Seeing none, we have some appointments. The Agriculture Fairs and Field Days Capital Program Advisory, Senator Collmore. Building Energy Code Working Group, Senator Bongartz. Vermont Climate Council, Will Eberl of Capstone. Recreational Facility Grants Program, Senator Westman. Regional Economic Development Grant Advisory Committee, Senator Clarkson. Vermont Veterans Memorial Cemetery Advisory Board, Senator Major. Working Lands Enterprise Board, David Hubbard, Alicia Utter, and Allison Lowe. Senator from Chittenden.
Thank you, Mr. President. I would move that the Senate stand in adjournment until 11:30 a.m. Friday, April 25th.
The senator from Chittenden has moved that the Senate stand in adjournment until 11:30 a.m. Friday, April 25th, 2025. Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and we've adjourned till 11:30 a.m. Friday, April 25th, 2025.